All attendees are in listen-only mode.
Good afternoon. This is Kieran Bastible and Jonathan Rogoff from the Kirschbaum PC Employment Law Group. Thank you all today for gathering remotely to attend our webinar, which is titled Employer as Hostage, How to Terminate FMLA Covered Employees. Before we get into the substance of today's webinar, just briefly about our firm, which I guess many of you might have some dealings with. Our name partner, Ken Kirschbaum, is rightfully known as the legal authority in the field of the alarm industry and has written extensively on that topic. Beyond that subject matter area, we are generally a full-service law firm, including our labor and employment group. That's what we're here today to discuss. And this troublesome issue for employees on FMLA leave and terminating employees while on that leave or if they're abusing that leave. So just to start, we're going to briefly discuss the FMLA general leave standards. And Jonathan, why don't you take over from well, look at today's agenda first. Those will be the topics that we're going to be briefly discussing. We're going to split those up. And then at the end, and not covered by this slide, we are going to do a brief survey of some notable FMLA-related case law in the United States within the past several years. While this is a pro-employee area of the law generally, we'll discuss some cases that were pro-employer, and we'll try to get some takeaway points out to you in connection with those cases that may guide you heading forward in connection with dealing with your own employees.
Hi, my name is Jonathan Rogoff, and I'll start off with the FMLA leave standard. The Family Medical Leave Act provides eligible employees up to 12 work weeks of unpaid leave and requires group health benefits to be maintained during the leave, as if employees continue to work instead of taking the leave. Employees are also entitled to return to their same or an equivalent job at the end of their FMLA leave. Under the FMLA, eligible employees are entitled to take, and employers must grant, intermittent FMLA leave or leave on a reduced schedule when their own serious health condition renders them unable to do their job. FMLA leave may be taken intermittently or on a reduced leave schedule under certain circumstances. Intermittent leave is FMLA leave taken in separate blocks of time for a single illness or injury. A reduced leave schedule reduces an employee's usual number of work hours per work week or hours per work day.
Now, in terms of FMLA leave certification, you don't just have to take the employee's word that they have this quote-unquote serious health condition or a family member has that condition. You can ask for some certification. As concerns the employee themselves, you can request certification from a doctor that that employee in fact needs FMLA protection. You can ask for new or additional certification from the employee at the start of each FMLA year. And that year would, of course, start to run from the first time that the employee takes FMLA leave. You're also entitled to ask for a second or third opinion, at your own cost, that is employer cost, before granting FMLA leave.
If the employers doubt the need for their employees to take intermittent leave under the FMLA regulations, they are entitled to investigate the certification and request that the employee undergo a second opinion from a different physician. The employer can directly contact the employee's physician to clarify the medical certification. However, the employee's direct supervisor is not allowed to inquire directly with the employee's physician. Only an HR professional, a leave administrator, or a management official is allowed to make a certification inquiry.
And again, that would just help make sure that the decision whether to grant FMLA leave is in fact a institutional determination and decision. You do want your HR professionals, to the extent you have them, actively involved in this process. Okay, now we're going to discuss what's called the honest belief standard in connection with the FMLA. The FMLA requires more than an honest belief on the part of the employer to deny an employee intermittent FMLA leave. The relevant regulations under the FMLA provide employers, several options to analyze whether a claim for intermittent leave by an employee is legitimate. They can request medical certifications, recertifications, checks for authenticity and clarification, and as discussed earlier, the second and third medical opinions at the employer's own cost of obtaining. An honest belief will not save an employer who denies an FMLA request without first exhausting all available avenues of communication and clarification with the employee. Now, we're going to briefly discuss a case later where the court involved found that a quote-unquote honest belief was enough to terminate an intermittent FMLA leave employee, quote-unquote, or an abuser of intermittent leave, to terminate from employment. However, as we will discuss, the standard that the court set in that case in terms of establishing an quote-unquote honest belief was quite high, and that's why we basically say, just your honest belief alone is not going to do it. You're going to need a blueprint for establishing that honest belief, which we will discuss in a little bit.
Next, we'll discuss an employee's standard call-out procedures. The FMLA regulations make clear that an employee must comply with an employer's usual and customary notice and procedural requirements for requesting leave, absent unusual circumstances. If the employee does not follow the company's usual notice and procedural requirements, and no unusual circumstances justify the failure to comply, FMLA protective leave may be delayed or denied.
Now, you may be asking, how do you establish that you as an employer have a usual and customary notice and procedure requirement? The most obvious way would be a clearly written and widely distributed employee handbook, which if any of you out there don't have, you should certainly consider getting in place as quickly as possible, because that is one way of proving that, in fact, the employee had notice of the line that they had to toe in connection with requesting leave. We here at Kirschenbaum have done many of these employee handbooks, and we would be happy to assist you in connection with formulating your own. Our emails will be shown at the close of this webinar, and if you have any questions, of course, we would be happy to address them with you.
Now we will discuss transferring an employee's role. An employer may also temporarily transfer an employee during the period of intermittent leave or a reduced schedule to another position within the company for which the employee is qualified and better accommodates recurring periods of leave than does the employee's regular position if the leave is scheduled for a medical treatment. The position may not be punitive and must have equivalent pay and benefits. Once the intermittent FMLA leave is over, the employee must be reinstated to the same or an equivalent job as he or she had before the FMLA leave request.
So what does that mean to you? It gives the employer some flexibility in shifting the employee's role during the period of intermittent leave or reduced schedule. However, as Jonathan said, it can't be punitive, i.e., the position must be equivalent in terms of pay, in terms of hours. In other words, you should think twice before shifting a day employee to the midnight shift, or otherwise making their position less palatable to a court who might be reviewing your action later.
Now we discuss the FMLA employee termination standard. FMLA leave does not provide employees with any greater rights to reinstatement or other benefits and conditions of employment, including continued employment. An employer may terminate an employee regardless of FMLA leave status, provided that there is a legitimate, non-discriminatory reason for the termination.
I don't think that we can stress that point enough, and I think it's one of the major takeaways you should be leaving here today with. You're not held hostage, despite the title of our webinar. You can terminate an employee on FMLA leave or not, provided there is, quote, a legitimate, non-discriminatory reason for termination. Again, your decision in this regard can be Monday morning quarterbacked by a court should the employee deem fit to commence suit. So you've got to make sure that you've got your ducks in a row in determining that, in fact, there is a quote-unquote legitimate non-discriminatory reason for termination.
Some of these reasons for termination are as follows. Employers may terminate employees who are on FMLA leave due to infractions or poor performance that come to the employer's attention during the leave, as well as insubordination, fraud, or other prohibited conduct while out on leave. Also, an employee who is on FMLA leave may be considered for a layoff during a reduction in workforce so long as the employee is not chosen for the layoff on the basis of the FMLA leave.
And while it's beyond the scope of this webinar, any employer considering a reduction in force, particularly if any of the force to be reduced is over the age of 40, really has to make sure that they're complying with the relevant laws and regulations in this regard. Again, it's beyond the scope of this webinar, but if you're considering a reduction in force, one or more employees over the age of 40 in particular, that you consult a labor and employment attorney before you take any steps in that regard.
Now we'll discuss the burden of proof. Title VII of the Civil Rights Act of 1964 indicates that the burden of proof for employee termination is ultimately on the employer. Employers must demonstrate that the employee would have been terminated or laid off despite having taken an FMLA qualified leave. Due to this burden shifting, it is important and necessary to keep thorough documentation of an employee's performance record so that the reasons for termination can be demonstrated to a court when litigation ultimately ensues.
Again, this is another point that cannot be stressed enough. We have many employer clients call us regarding a decision to terminate an employee that for whatever reason, due to malfeasance or nonfeasance, is just not getting the job done. And they recount to us countless instances that in fact the employee was talked to, but nothing was ever put in writing. We cannot stress enough that if in fact you have issues with employee performance, you call in that employee, hopefully in the presence of a witness, and you hand them a memo that outlines your concerns, proposed course of action going forward, and if possible, ask the employee to sign and give the employee their own copy of such a memo. You really have to have your documents in a row. You know, this is litigation avoidance in the first place, but if you're dragged into court, you're at least going to have some record, contemporaneous record, not one created well after the fact, that the employee had been counseled, warned, etc. And so you know everything should be in writing.
Complying with the FMLA's record-keeping obligations and demonstrating the existence of an FMLA policy and postings, as well as a track record of allowing employees to take FMLA leave without reprisal, are necessary standards employers can use to prove that the employee is not being terminated for a discriminatory reason. Courts have regularly held that employees on FMLA leave can be terminated for violating company rules, poor performance, or because of a reduction in force. Based on the particular circumstances surrounding the employee's termination, however, additional proof will be required to establish that an employee was terminated for a legitimate, non-retaliatory reason unrelated to FMLA leave.
And again, how's that additional proof going to be presented by the employer? Your prior documentation that you have procedures in place that when the employee is being counseled or warned that you did so contemporaneously with the events that brought the reason for the counseling to light, and that these are written in writing and witnessed.
Now discussing a reduction in force. When an employer has a valid business reason for conducting a reduction in force or for eliminating positions, an employee on intermittent FMLA leave can still be laid off even while on the leave, assuming the employee would have been laid off if the employee was still working. As true in any layoff, regardless of whether the issue is a potential FMLA claim, a potential age discrimination claim, the employer should not only be prepared to establish the business necessity of the layoffs, but should also follow prescribed objective guidelines for determining who will be laid off and why.
And again, reduction in force, particularly involving older employees, should be undertaken very carefully and only after consultation with a labor and employment lawyer.
Now we discuss misconduct or poor performance. An employer can also avoid liability when terminating an employee on FMLA leave if it can demonstrate that it had a legitimate performance-based motives for terminating the employee. The employer must be able to demonstrate why, if the employee's performance warranted termination, the employee was not terminated prior to going on leave. This is often less difficult than it may seem, because the grounds for termination are often not apparent until other employees who are covering for the absent employee's shift discover what a mess their colleague has left behind.
Okay, now we're going to turn to some recent case law of note in the FMLA field. And as I stated earlier, if cases go to court, the employer is sort of on the defensive and has a higher burden than the employee. Some of these decisions that I'm going to discuss now are pro-employer, and I'll try to give you a takeaway from each of them. First one we're going to discuss is Escriba versus Foster Poultry Farm, which was a Ninth Circuit decision from 2014. The fact pattern here, and you as employers may deal with, what do you do if one of your employees has informed you of what is clearly an FLMA triggering event, but in this case, this employee needed to leave the country to take care of her dad who was seriously ill in the hospital. But then that employee tells you she doesn't want the absence to be FLMA leave, she wants it as vacation time. Can you do it? In Escriba versus Foster Poultry Farms, the court found that yes, in fact, that the employee could designate the leave as vacation. The facts here were that the employee who had English as a second language went to a direct supervisor and asked time to take care of her dad in Guatemala. She stated, quote, "Linda, for me, vacation," end quote. The supervisor responded, "Okay, Maria, you vacation," and told her that she'd have two weeks of vacation. Maria needed a little more time than that, and so she approached Linda again and said, "Please, 1 week or 2 week free for me," end quote. Since English was a second language, they then used a supervisor who was fluent in Maria's native language, and she said, "I'm on my way to Guatemala because my dad is ill. I'm only going with 2 weeks vacation, but I want to know if you could do me a favor and give me 1 or 2 more weeks leave." and the supervisor said he couldn't provide any additional leave. She then went to Guatemala. She remained there well past the vacation leave she'd been provided, and she didn't contact the employer until 16 days after she was scheduled to return to work. She was terminated as per company policy, and then filed an FMLA interference claim. Her claim was pretty straightforward, that the reason for her leave, that is caring for her ill father, triggered FMLA protection. She notified the employer of the need to leave for this purpose, so the employer was obligated to designate her absence as FMLA leave. The court here didn't buy it, I think mostly because Maria had been a previous FMLA frequent flyer. That means that she had taken FMLA leave on 15 different occasions in advance of this latest episode. Since the court looked at this and said, look, she had the ability to know how to ask for FMLA leave. She'd done it previous to this, and hence she could affirmatively decline FMLA leave in this instance and try to use it as vacation. While this is a pro-employer decision, I would assert here that in fact this case is an outlier, and I wouldn't risk relying on a similar outcome under a similar circumstance in the future. A better practice for employers is to designate all absences such as these as FMLA leave. One, because it avoids an administrative nightmare, in terms of trying to truly divine the intent of an employee. Secondly, it would designate an absence as FMLA leave when it qualifies as such, protects the employee's job, which, otherwise, if it's not designated as FMLA leave, the employee's absences are subject to the employer's policies of, vacation and leave without absence. So, and as a last point, as a practical matter, you would want your employees to exhaust their FMLA leave sooner rather than later. Because if there are going to be problems in this regard, and if they're going to take leave above and beyond what they're entitled to under the FMLA, you would want to be in a position to think about termination for non-discriminatory reasons sooner rather than later. So again, good result for the employer. I wouldn't rely on it too much. Okay, the next case I want to discuss is Vest versus Select Medical Corp, Northern District of Ohio, decision 2013. This is a very interesting one for you employers. Okay, and the issue here is, what, if anything, can you ask an employee out on FMLA leave to do? Ms. Vest was a head of respiratory therapy at a senior facility in Toledo. She went out on leave after a leg injury falling in the employer's parking lot. While she was out on leave, she did what she claimed was work for the employer, which included fielding calls from her supervisors about scheduling, fielding calls to discuss her work duties and absences, inputting data on behalf of the employer, and completing some training. She came back from leave and shortly thereafter was terminated for acting outside the scope of her authority in terms of dealing with doctor's orders. She immediately turned around and sued her employer for a case alleging FMLA interference, in that she had been asked to conduct so much work over the phone during her absence that her FMLA leave was interfered with. The employer tried to make a motion to dismiss her claims, but the court found that under these circumstances, she had made a valid claim for FMLA interference, sufficient enough to take her case to trial. And for the employer, that would equal either a very expensive trial or a almost as expensive settlement. Okay. The Vest Court did issue some guidelines in this ruling as to the narrow scope of what, in fact, employers can ask of employees out on FMLA leave. The court said that the following were permissible: passing along institutional knowledge to new staff, providing computer passwords, seeking closure on completed assignments, and identifying other employees to fill voids in the workplace. Requesting anything more than this from workers can put you in violation of the FMLA and open to a claim for FMLA interference. So this was a pro-employee decision. Next, Tillman versus Ohio Bell Telephone, a Sixth Circuit decision. Jonathan and I stated earlier that a quote-unquote honest belief wasn't enough to terminate an FMLA abuser. Here, the court found that a quote-unquote honest belief was enough, but provided a pretty strict blueprint as to what an employer would have to do to make their quote-unquote honest belief sufficient. Tillman worked nights with Ohio Bell customers. He was diagnosed with severe back problems. He applied for and was granted 2 to 3 days of intermittent leave per month under the FMLA. First red flag the company noticed was that he was regularly using up to 6 days a month, which was well over the allotted amount of 2 to 3 days per month. They then saw, as time went on, that the days he frequently took leave fell on days surrounding his regularly scheduled days off, i.e. making himself a longer weekend, 3 or 4 day weekends. The third red flag was as time went on, he began notifying the company of days in advance that he would be unable to go to work because of FMLA leave. For example, next Friday, I'm going to be out on FMLA leave. That raised concerns from the employee, and rightfully so, as to whether, in fact, this was an intermittent FMLA abuser. So what did Ohio Bell Telephone do about it? First, it hired a professional investigator to conduct surveillance on Mr. Tillman, and that investigator found him running errands and working in his garage on days that he was out on intermittent leave. Again, they took close track of the days he in fact took and made a case that in fact not only was he giving himself long weekends, but was taking days off in advance. Finally, it retained an independent medical doctor to review his certification forms, the surveillance findings of the private investigator, and the job description. And the doctor concluded that the actions of Mr. Tillman were not consistent with that of an individual suffering from alleged severe back pain. Physician also concluded that the employee didn't have a serious medical condition that would have prevented him from doing his job duties on days that he was taking leave. This case wound its way to the appellate court, which ruled that based on these facts, as I've outlined them, that Ohio Bell had an honest belief that he was abusing FMLA and that his termination was justified. But again, look at the blueprint that Ohio Bell did, establish here, including a medical professional and a private investigator. That is a truly honest belief based on justifiable facts, that if in fact you terminate an employee based or an alleged FMLA abuser based on your honest belief, are you going to be able to make such a case as Ohio Bell did here? Next case, Kosarsky versus A.O. Smith Corp., which is a District of South Carolina case 2014. This is a pro-employee case. Here's the scenario for you. Let's say you give an employee a month's notice that he needs to be at work on back-to-back days for mandatory training. Shortly after he's advised that, he tells you he needs to take those days off because he's having granite countertops installed in his house. You deny that request. The day before training, he repeats the request for the days off, and he claims that he, quote, needs to unwind, end quote. Again, that request is denied. He then fails to show up on the training days, and he's fired. When the employer calls the employee to break the news, his wife said he was absent because he had an anxiety attack. He now says he's needed to take FMLA leave, and he sues for FMLA interference. Who wins? Guess what? It wasn't the employer here, despite its belief that the employee was faking the anxiety claims. Here's why. The court found that in the months leading up to his termination, multiple co-workers of the individual had approached management with the reports that he was acting unusually, including starting rambling conversations. Shortly before his termination, his supervisor had informed the HR department that he had mentioned feeling stress, wanting counseling, and planning to call his doctor. He'd also told his supervisor at one point that he was bipolar and taking antidepressants. Following his termination, the employer sent him FMLA documentation to try to better understand the reason for his absences. He returned the paperwork with a doctor's certification indicating he was suffering from a quote-unquote serious medical condition. This is a classic example of how courts put the burden on employers to prove a worker wasn't protected by the FMLA at the time of his or her termination. He'd never spoken the magic words, quote-unquote FMLA or medical leave prior to the absences. Plus, his excuses gave no indication he needed time off for medical reasons. But the employer is now on the hook because due to the employee having acted strangely or having an asserted history of illness, the employer should have anticipated that, in fact, his need to unwind could have been a request for FMLA leave. So again, if you as employers have any prior knowledge of an employee acting strangely, complaining about medical issues, try to grab the bull by the horns prior to any termination and see if, in fact, there are grounds for valid FMLA leave. Finally, one other case, which again goes into an area of law which is grist for a further webinar, including which is overlap between the Family and Medical Leave Act and the American with Disabilities Act, is the Atiogbite versus Southeast Rolling Hills case, which in this matter, a district court case out of Minnesota, a nurse provided her employer with a note saying that she couldn't kneel, squat, or lift more than 50 pounds. She asked for leave under the FMLA, and the employer gave her 12 weeks off. Following that leave, she returned complaining of the same situations and asked for additional leave under the Americans with Disability Act. Here was a court or a pro-employer decision by this court in Minnesota. Because the employer showed clear evidence that the employee's request would present a quote-unquote undue hardship on the company. Accommodating her lifting restrictions, i.e. she couldn't squat or kneel, would effectively mean she couldn't do an essential part of her job as an LPN in this senior nursing facility. Her request for additional leave was found to also be an undue hardship because the company had already spent upwards of $8,000 to replace her during her FMLA leave. Finally, the company showed the employee's continued absence would negatively affect her co-workers' performance. And the takeaway from here is because, and again, we may have a separate webinar in the future about this, requesting additional leave is becoming a common accommodation request when employees exhaust their FMLA leave. It's important for you as employers to remember that you don't have to accommodate each and every request. If you can prove that the requested accommodation under the ADA, presents an undue hardship on your company or other employees. Under those scenarios, courts are more likely to side with your firm. Finally, before we close here, I would just like to bring up one issue which isn't on a slide as to why the FMLA and your establishing proper policies and procedures in connection with therewith are important. If and when these cases go to trial, courts are continually finding and more recently that in addition to the damages that the employee proves, Yet the employees will also be awarded liquidated damages in a sum that would double the amount of damages that they have proven. And the reason why, under many of these cases, that liquidated damages are awarded, the court finds, quote unquote, no good faith, end quote, on the part of the employer. According to these decisions, you as employers bear a substantial burden to prove good faith in connection with your FMLA leave decisions and subsequent termination decisions, and that there is a presumption that the employee is entitled to the liquidated damages that you must overcome. To do this, you must prove that you act with a subjective intent to comply with the FMLA, and subjective means in your own minds as employers. That sometimes can be very difficult to prove, and that you act objectively reasonable in your application of the FMLA. Objectively would be, your outward manifestations of what you in fact did. I would say that outward, objective intent is much more easier to show a court or any third party than subjective intents. So if in fact you're brought to court, unless you have all your ducks in a row, for lack of a better term, if the court rules in favor of an employee, you can expect double damages in the form of liquidated damages. I think that brings us to a close today.
Yes, and thank you. And if you have any questions or any concerns or comments, please don't hesitate to call us at 516-747-6700, extensions 315 or 307, or send us email inquiries at the emails in front of you.
And we hope you had some takeaways today that are helpful to you in your dealings with your employees going forward. We thank you for your time and attention. And again, if you have any questions, Jonathan and/or I would be happy to answer them and assist you in any way we can. Thanks, everybody, and have a great afternoon.